I sent a message earlier that I will join the class by 2:25. Did you get the message? Hello?
Hello, sir. Hello, sir. We can hear you, sir.
Did you get my message that we are starting by 2:25?
Yes, sir.
Okay, so we are good to start now. During the last class, I was able to analyze to you the actus reus element of the offense of murder. I've told you that the elements to look out for when you are establishing the commission of murder, first and foremost, must be established that the person died, that there is death of a person. And how do you prove that somebody dies? It's through medical evidence, although there are exceptions. Okay? Death, the circumstance, the fact of death, and the cause of death. Okay? Because the medical report will indicate the cause of death. Okay? Then after that, I told you that it must also be established that the act or omission of the accused person caused the death of the deceased. That was what we were discussing that led us into the issue of causation. And I told you about the de minimis rule, that the act or omission must have been a substantial contributor to the death of the deceased. I've given you about 6 different instances where the chain of causation may either remain unbroken or may be broken. You know, you have them. Then we later started the mental element, that is the menstrual. And in discussing the mental element, I also made you to realize that the mental element of murder, just like every other offense, is construed through intention. Intention. But that there is always a problem in the proof of intention, because even the devil does not know the mind of man. So how do you know what a person intends to do and did? I told you in most cases, intention is construed through inferences and circumstantial evidence. So you draw inference from circumstances of the case. And that was when I brought in the position of Professor Bangboshe on this matter, that some of the circumstances and factors that will assist the court in construing the intention of the accused person includes the type of instrument used, tools, the type of object used in the commission of the offense. And the second one is the part of the body struck, the part of the body. If you strike the head or you strike the chest or abdomen, it will be easily construed that you intend to kill than when you strike the leg or the back. Okay? So I was trying to explain the issue of part of the body struck when we ran out of time the other time. But I think I've explained weapon use, the type of weapon used, you know. And I gave you the case of Igago versus State, where the appellant hit the deceased head with shovel, and he died on the 3rd day. And the court held that the use of lethal objects and dangerous weapons may lead to the inference that the accused intended to kill or cause grievous bodily harm. So today we are proceeding with part of the body struck. Like I said, there are parts of the body that are more sensitive than the others. So if the attack is on the chest, that is where your heart is. If the attack is on your head, yes, there is likelihood that death can result. And if it's abdomen, also very sensitive. So according to Bangboshe, he cited the case of Aga versus the State. Aga and State is AGA versus the State, 1976. 7 SC 173. 1976, 7 SC 173. The accused kicked a 5-month-old pregnant woman in the abdomen. You can see what we are saying. The accused kicked a 5-month-old pregnant woman in the abdomen and she died. It was held that it can be inferred they are intended to cause grievous bodily harm. By the time we start looking at Section 316, subsection 1 to 6, in determining the type of intention that the accused person had, you will realize that the provision of Section 3161 is talking about it suffices to construe intention to kill if either the accused person intends to kill and he kills, or he intends to cause grievous bodily harm and it results in death. So those are sections 316(1) and section 316(2). But before we get to that, we are looking at the types of intention that can actually make you to establish the case of murder against the accused person. Also, in Titus Annum is spelled, Annum is ANOM versus the state. That's 1972. That's 1972. 12 SC 56 to 59. 12 FC 56 to 59, where the accused used the butt of a gun to hit the deceased on the chest. See what we are saying now. He used the butt of the gun to hit the deceased on the chest. The court held that intention to cause grievous harm can be inferred. You can see now. So the third factor under this particular segment of how to infer intention to kill is the degree of force used. Degree of force used. Is it intense? Is it a slight one? But is it very intense? If it is intense, intention to kill will be easily construed. Intention to kill or cause grievous bodily harm can be inferred from the application of hard force. Hard force. See the case of Kim versus the state. Kim is KIM. Kim versus state. Kim versus the state. 1992. For NWLR, part 233 at 17. 1992. For NWLR, part 233 at 17. And the fourth condition, the fourth parameter to consider in construing intention is quantity of drug or type administered. Quantity of drug or type of drug administered on the deceased. So if, for example, the accused person intends to kill the deceased with poison, and you administer the kind of poison that is so clear cannot kill a person, you may not be able to convince the court that the accused person intended to kill the deceased. So, on the quantity of drug or use, drug use or the type, see the case of Osadiaye versus the state. Osadiaye is spelled Osadiaye, where the court held that putting 3 tablets of madras in the deceased drink, madras is spelled MADRAS, putting 3 tablets in the madras, so 3 tablets of that madras in the deceased drink was not likely to endanger human life. The prosecution must be able to prove that the accused person formed an intention to do any of the acts or omission contained in section 316(1) to 6 of the Criminal Code. There was a particular session where this constituted the question, the essay question that came up on murder. We asked candidates to analyze critically the provisions of section 316(1) to 6 in relation to menstrual element, establishing the menstrual element of murder. Quite a lot of you didn't answer it satisfactorily. So analysis of section 316, 1 to 6. Under section 316, 1 and 2. Section 316, subsection 1 and 2. Murder is committed when there is proof that the accused intends to kill or cause grievous bodily harm. Murder is committed when there is proof that the accused intends to kill or cause grievous bodily harm to a person or another, and death occurs. Note, to a person or another. As in OGBA versus the state, 1992, 2 NWLR, part 222. Ogba State is cited 1992, 2 NWLR, part 222, at 164. At 164. See also Okere Mute versus the state. Okere Mute versus state is spelled OKEREMUTE. Okere Mute versus state, 2021. Okere Mute and the state.
Please, sir, I didn't get the case you just mentioned, sir. Please, I mentioned. Repeat the case.
Mute. I gave you the case of Ogba versus state first. Did you get that one? Did you get Ogba versus state?
The citation, sir.
Which one? Is it Ogba or Okere Mute?
Ogba, sir.
No, sir, I didn't get the first.
The first case is Ogba versus state.
Okay. Yes,
1992, 1992, 2 NWLR, part 222, at 164. 1992, 2 NWLR, part 222, at 164. Then I also gave you Okere Mute versus state. Okere Mute is spelled OKEREMUTE. Versus state.
Thank you.
2021, 16 NWLR, 16 NWLR, part 1803.
Thank you, sir.
Part 1803 at 587. At 587. At 587. So, having earlier discussed proof of intention to kill, it is necessary to examine the purport of the phrase grievous harm. I told you section 316, section 1 says that if you intend to kill or you intend to kill another person and death results, then it will be construed that you have intention to kill. However, if there is evidence that intends to cause grievous bodily harm and death results, the intention to cause grievous harm suffices to make you liable for murder. So you don't need to have express intention to kill. If you have intention to commit grievous harm, then you are liable under the section for murder. So what is grievous harm? Section 1 of the Criminal Code defines it as any harm. Section 1 Criminal Code defines it as any harm. Defines it as any harm which amounts to maim as in M-A-I-M. Any act amounts to maim, dangerous harm, dangerous acts, dangerous harm, or seriously or permanently injures or extends to permanent disfigurement. or seriously or permanently injures, or extends to permanent disfigurement, etc. You have to note that the intention to kill or cause grievous harm need not be formed for the person actually killed. The intention to kill or cause grievous harm need not be formed for the person actually killed. But it suffices if it is formed, construed to be formed for another.
Sorry, sir, we didn't get that.
Okay, I said Section 1 of the Criminal Code defines grievous harm as any harm which amounts to maim as in MAIM, dangerous harm, or seriously or permanently injures or extends to permanent disfigurement. And I said the intention to kill or cause grievous harm need not be formed for the person actually killed. It suffices if the intention is formed about another person, if the intention is formed as regards another person. See Garki versus State. Garki versus State. Garki is GARKI, 1979, LRNN, Law Report of Northern Nigeria, LRNN, at 38. See also Basoyin versus AG Western Nigeria. Basoyin is spelled BASOYIN.
Sir, call the citation again. Your network is breaking.
Citation for Garki, right? Is it for Garki?
Yes, sir. Yes, sir.
1979, LRNN, Law Report of Northern Nigeria, LRNN, at page 38. You get it? At page 38, and also Basoyin versus AG Western Nigeria. Basoyin versus AG Western Nigeria, 1966, NMLR 287. Basoyin versus AG Western Nigeria, 1966, 13 LWLR, part 1372. Basoyin versus AG Western Nigeria, 1966, sorry. NMLR. Basoyin versus AG Western Nigeria, 1966, NMLR 287. Did you get that?
Yes,
Did you
sir.
get that? Okay. So in the case of Julius Abifiron, Abifiron is spelled ABIFIRON versus the state. In Julius Abifiron versus state, 2013. 2013. 13. Who is that now? Hello?
Hello, sir.
Okay. I said in Julius Abifiron versus the state, Abifiron is spelled Abifiron, 2013. 13 NWLR, part 1372, and 619. The Supreme Court stated that in addition to the requirement of intention to kill or cause grievous bodily harm, the prosecution must also prove that the accused person had knowledge that death or grievous bodily harm was the probable consequence of his act or omission. That the prosecution must also prove that the accused person had knowledge that death or grievous bodily harm was the probable consequence of his act or omission. Note that intention to kill is different from intention to cause grievous harm. Note that.
Could you please take that part again?
Note that I said in Julius Abifiron State, 2013, 13 NWLR, part 1372 and 619, the Supreme Court stated that in the prosecution, that the prosecution must also prove that the accused person had knowledge that death or grievous bodily harm was the probable consequence of his act or omission. Then you know that it's different from intention to cause grievous harm, and the prosecution must establish the specific intent. Intention to cause grievous harm and intention to kill are not the same, but the prosecution must establish the specific intent. So in Oladipo versus the state, Oladipo versus the state, Oladipo versus state, 1993, 6 NWLR, part 298 at 131. Oladipo versus state, 1993, 6 NWLR, part 1372 at page 619. The Supreme Court stated that in addition to the requirement of return to kill or cause grievous bodily harm, the prosecution must also prove that the accused person had knowledge that death. So no, I'm talking of Oladipo versus state, 1993, 6 Nigeria Killer Report, part 298 at 131. Do you have that? Hello?
Yes, sir.
Hello, sir.
Oladipo versus state, 1993, 6 Nigeria Killer Report, part 298 at 131. The Supreme Court held that the appellant who threw a plier at the deceased during an altercation between them will not be properly convicted for murder because the lower court did not make a specific finding that he intended to cause grievous harm to the deceased. Because the lower court did not make a finding, don't make a specific finding that he intended to cause grievous harm to the deceased. See also Festus Amayo. Festus Amayo versus the state is 2002, 5 WRN at 115. Amayo and state 2002, 5 WRN at 115. It's a Supreme Court decision. So that is the analysis of section 316, subsection 1 and 2. Intention to kill and the person dies, or intention to cause grievous harm which results in death. Both are usually taken together. So we move on to section 316, subsection 3. And what does 316, subsection 3 say? It says that if the act was done in the prosecution, the act resulting in death, if it was done in the prosecution of unlawful purpose, likely to endanger human life. This aspect is very, very important. Unlawful purpose, prosecution of unlawful purpose, likely to endanger human life. So what we are saying here is that there are two elements that are involved. There are two elements that are involved. One, that the act of the accused was done in the prosecution of unlawful purpose. That the act of the accused is likely to endanger human life. That's the second one. The first one is the act of the accused was done in the prosecution of unlawful purpose. And such acts is likely to endanger human life. These two elements are separate and they must be distinguished from each other. So in the case of R versus Nameri, 1951, 20 NLR at 16, this case, I don't think, left to me, is not a good decision, but what can somebody do? That's the position of the court. I'm sure if the facts come up again these days, it can be held the other way around.
Sorry, sir, the spelling of Nameri, sir. The spelling of Nameri.
Nameri is Nameri. Nameri, N for Nigeria. Ameri. Nameri.
Thank you, sir.
1951, 20 NLR at 16. Where the court held that rape of a 13-year-old girl was not capable of endangering a woman's life. So look at this Nameri now. Section 316 of 3 said the act must be done in the prosecution of unlawful purpose, and that it must be capable of endangering human life. If we look at rape, definitely rape is unlawful. I hope you know. I hope you know that rape is unlawful.
Yes, sir, we know rape is unlawful.
Yes, sir.
But the subsection further requires that that act must also be capable of endangering human life. So in Nameri, the accused person raped a 13-year-old girl, and the girl eventually dies. And the court held disappointingly that raping a 13-year-old girl was not capable of endangering a woman's life. I don't know if you understand what I'm saying.
Yes,
so
sir, we understand.
We understand, sir.
The court admitted that the death resulting from the rape is a death resulting from the prosecution of unlawful purpose. Yes, which I said earlier. But that since the girl was 13-year-old, she was more or less a mature girl, and that raping a mature girl does not necessarily need to be seen as endangering a woman's life. So, however, in the case of DPP versus Beard, Beard is BEARD, 1920 AC 479, 1920 AC 479, which is also a rape case, where the accused held the throat of the victim while the rape was taking place, and the deceased died. It was said that the two requirements are met. It was said that the two requirements are met, that the rape was an unlawful act, then holding the throat of the deceased was an act capable of endangering human life. So the court held, quite unlike decision in Nameri, in Beard, the court held that the two requirements are met. So you can compare Nameri case with the Nigerian case of Idowu versus State. Idowu versus State is 2012 NWLR, part 680 at 48. Part 680 at 48. It must be noted that this case of Beard is also applicable to section 316, subsection 6. It's also applicable to 316, subsection 6, pressing of somebody's throat. You know, when we get to 316, subsection 6 now, you will see that it has to do with Beard again. So in R versus Okoni, Okoni is spelled O-K-O-N-I. Okoni is spelled O-K-O-N-I. 1938, for Waka at 19. It's a Nigerian case. 1938, for Waka at 19, where the accused set fire on a house with an intention to drive out a man who was believed to be hiding there. And a woman got burnt in the process. The court held that it qualifies for murder under Section 316, Section 3, that the two requirements are met, because setting fire on a house is an act that is capable of endangering human life. They are even attempting to send somebody out of a house is an unlawful act. It's a prosecution of an unlawful purpose. Okay? Now, abortion and obnoxious liquid case of R versus Gold is also a relevant case here. There's R versus Gold, which has to do with abortion and administration of obnoxious liquid to secure an abortion. It also qualified under this subsection. And the Nigerian cases of Akikumi and others versus the state, Akikumi and others versus the state, 1987, 1 NWLR, part 52, and 608. And Showemimo and others versus the state, 2004, 7 MJSC 183. 7 MJSC 183. The citation of Gold is 1960. The citation of Gold is 1960. QDR at 283. Gold is 1960. QDR at 283. So you have to take note of Section 316, subsection 3. You have to take note of Section 316, subsection 3, because we usually examine students on this.
Sorry, sir. That Showemimo, is there age in that Showemimo or there is no age?
Showemimo, there is no age.
Okay, thank you, sir.
SOW, yeah.
Okay.
So you have to take note of Section 316, subsection 3, because we usually examine candidates from this area, so that you can be able to distill. You can be able to distill the difference between the facts of the case in Beard and the facts of the case in Namiri. Both cases have to do with rape. But in one case, in Namiri, the court held that the two requirements are not met. Whereas in Beard, the court held that the two requirements are met. So take note. Yeah. So,
excuse me, sir. Good afternoon, sir.
Good afternoon.
Good afternoon, sir. Sir,
good afternoon.
Section 316. Good afternoon.
Yes.
Section 316 on subsection 3 provided two conditions. I want to ask, those two conditions, must they be visible? Must they be apparent before one can actually say someone is guilty of murder?
Let me have your question again. I can't understand what you are saying.
Hello, sir.
Yes.
Sir, I say from the section we just read.
Yes.
There are two conditions, either unlawful purpose or endangering human life. Now, these two conditions, must they be
prosecution of unlawful purpose, then the act that results in the death of the deceased must be an act that is capable of endangering human life. So if it is just prosecution of unlawful purpose and somebody dies, it will fail under Section 3163, unless it can also be proved that that act is capable of endangering human life, which was not able to be established in Nameri's case. Okay.
Understood, sir. Thank you.
Okay. Section 316, subsection 4. 316 has to do with death that results from grievous harm. Yes.
Yeah, you mentioned a particular case before Shuemimo's case, so I didn't get that case. I wanted to.
Akekumi and others versus the state, 1987, 1 NWLR, part 52 at 608. Akekumi and others versus the state. I earlier mentioned the case of gold. Gold is G-O-U-L-D, not G-O-L-D, G-O-U-L-D, where I said it was in the process of carrying out an abortion, obnoxious liquid was administered on the victim, and the victim died. So it was held that it satisfied the requirement of Section 3163.
Hello, sir.
So you know, abortion is unlawful. That's the prosecution of unlawful act purpose. Then the act resulting in the death, that is administering obnoxious liquid. Is it capable of endangering human life? The answer is yes. So that was why the case qualifies under Section 3163.
Hello, sir.
Okay. Yes.
Okay. I want to I observed something about the two cases you mentioned, the Nameri and the DPP one. So I want to observe whether I think they are there is no distinction between two of them, because
there's distinction. The commonality between both of them is the fact that they both have to do with rape cases. Apart from, from the fact that the girl in Nameri is a 13-year-old girl, and which God believes that it is not unusual for 13-year-old, 14-year-old, 15-year-old to have intercourse. So raping a 13-year-old girl, the court said that yes, it's an prosecution of unlawful purpose, you know, but it is not capable of endangering human life. Okay? But in Beard, coupled with the act of rape, the accused person held the throat of the deceased. And the court construed that to be an act that is capable of endangering human life, in addition to the fact that the rape itself is prosecution of unlawful purpose. Can you see the difference now?
Yeah, because in the DPP case, I was seeing the two causes of action there, because holding somebody's throat ordinarily is illegal. So I'm just, I'm just seeing two causes apart from the rape aspect. The holding of somebody.
The rape aspect is the prosecution of unlawful purpose.
Unlawful, and also the holding of somebody's.
Holding the throat is an act capable of endangering human life.
Okay.
So that is the difference between Nameri and DPP versus Beard. So Section 316 of Section 4 has to do with death that ensues from grievous harm inflicted in the process of facilitating the commission of an offense. In the process of facilitating the commission of an offense. For example, if people have gone to commit robbery, bank robbery, for example, and when they get to the bank to commit the robbery, you know, in order to facilitate the commission of the offense, you know, you give somebody who is trying to obstruct you, you give him a blow on the head, and the person dies as a result of the blow. It qualifies under Section 316, Section 4. A death that results from grievous harm inflicted in the process of facilitating the commission of an offense. In the process of facilitating the commission of an offense. So in R versus Akanyi, is spelled A-K-A-N-Y-I. R versus Akanyi 1955. 15 Waka at 84. R versus Akanyi, 1955. 15 Waka at 84. Where the accused went to rob. And when accosted by the deceased, who tried to stop him, he inflicted grievous harm on him in order to escape, and death results. He inflicted grievous harm on him in order to escape, and death results. The court held it to constitute murder under section 316, section 4 of the Criminal Code. The court held it to be murder under section 316, section 4 of the Criminal Code. See also Big Ben and others versus the Queen. Big Ben is spelled D-I-G-B-E-H-I-N versus the Queen. Big Ben and others versus the Queen.
Sorry, sir, the spelling of Big Ben again.
D-I-G-B-E-H-I-N. D for David. Big Ben. G-B-E-H-I-N. Big Ben versus the Queen is 1963. 1963, 1 ANLR at 388. 1 ANLR at 388. So that one is straightforward. So we move to 316, section 5. Section 316, section 5. Here, murder is committed where death is caused by administering any stupefying or overpowering substance or the person for the purpose of facilitating the commission of an offense. Murder is committed where death is caused by administering any stupefying or overpowering substance or the person for the purpose of facilitating the commission of an offense. When we are discussing the parameters for inferring intention to kill or to cause grievous harm, I refer you to the parameters as stated by Professor Bangushi. And one of the parameters, I think the fourth one, has to do with the quantity of the substance used in case of death by poison. The quantity of the substance used. And I mentioned to you the case of Osadiaye, where the court held that 3 tablets of a particular drug, Madras, 3 tablets, were insufficient to cause a death of a person, and therefore the court cannot construe that he had an intention to kill. So you take note of that. And now that we are in section 3165, which has to do with death resulting from administering stupefying or overpowering substance on a person for the purpose of facilitating an offense. So we also have Osadiaye versus State again, that same case for this particular, example. I don't know if you people can recollect maybe about 8 years ago or thereabout, there was a lady that was lured from Abuja to somewhere in Festac, hotel in Festac, for a particular business transaction. I think the lady happened to be a daughter of one retired military officer, a general. The lady came to the hotel to meet business partner, and in the process of discussing business, she didn't know that they are very dangerous people. So they had to overpower her and administer Rufinol. There is a particular drug called Rufinol. Rufinol will make you become unconscious to the extent that you will just be looking, you won't be able to resist anything. And it can be like that for like 2 days, 3 days, before, if you are lucky, you may regain consciousness. So in that particular case, the lady died. They raped her. They raped her after administering that overpowering substance to her. They raped her and she died. So that case is an example of this particular section 316, subsection 5.
Please, I have a question, sir.
Yes.
The case of Osagiaye versus the state. Please, sir, can you state the fact of the case again?
I said the accused person administered 3 tablets of Madras drug to the deceased, you know, with a view of poisoning her. You know, the court held,
and the court decision, yes, sir.
The court held that the quantity of administered the substance is not enough to prove an intention to kill. I don't know if you understand what I'm saying.
It's not enough, sir.
Yes,
so did you say it was not likely to? Okay.
Yes, that it is not enough to lead to death. That is not sufficient, you know, to the result of the intention to kill will not be construed.
Thank you, sir.
So you can also use that case under section 316, subsection 5. So we now move to the last element on menstrual of murder, proof of intention, and that is section 316, subsection 6. That subsection 6 says death. Yes?
I have a question, sir. So I wanted to ask that in the case of Osagiaye versus the state, for instance, where 3 tablets of Madras was administered, what if in that case, for instance, he wanted to commit an offense and then he wanted to drug the person and then he administered the 3 doses of Madras, but normally he's not supposed to kill somebody, but where the deceased now died, will this section also apply?
It will not apply if it is, you see, what the court was saying is that 3 tablets of Madras is not effective enough to kill a person. So if you want to infer intention to kill, the quantity of drugs or substance used on that person will be considered. If it is sufficient enough to cause death, then intention to kill will be construed. That's how that case came up. That 3 tablets of Madras is not enough to poison a person.
Excuse me, sir.
What I'm saying?
Okay, sir.
Hello, sir.
So what of in a situation whereby the person has an underlying ailment and then the administering that Madras, that 3 tablets of Madras, like helps like worsen the situation and the person dies, would that be considered like novus actus, or would this be considered as murder, like taking your victim as you find him?
Yes, you see what we are saying here. If you are talking of novus actus, novus actus in most cases is a situation where the accused person has carried out a particular act of omission on the deceased, which, if there is no interference at all, would have led to the death of the deceased. But an intervention setting, which is now capable of making the chain of causation to break. For example, somebody who was advised to stop, I think, is it drinking? Maybe it's drinking alcohol so that he will recover. And he persisted. A medical report says that the alcohol actually aggravated that wound and made him to die. It was he himself that ingested it. It's not like somebody administered poison to him. Are you following what I'm saying? So you see, you can differentiate it with novus actus. You differentiate it with novus actus. Novus actus has to do with intervention. The setting is already there. It's just an intervention. Okay? Or somebody who was pursuing his wife, threatening the wife, and the wife fell along the line and died. And it was later discovered that he has a defective gland. You see, that's a novus actus. But the court held that you take your victim as you find him, that it doesn't break the chain. Eggshell theory. Somebody refused medical advice or to take transfusion or to do surgery, and the person dies. You know, but if you look at Holland and Jordan, you can see, you know, another controversial issue. If there is no proper medical attention, you know, that the chain can break. But if there is proper medical attention and the person still dies, that the chain will not break. And you see the fact of Holland, you see the Jordan, almost the same, you know, and Smith. So these are issues here. These are issues here. So a very brilliant student should be able to analyze the distinctive features, even though the distinctions, dividing line may be very thin, you know, but you must be able to distill it, you know. So that is the issue. So 316 subsection 6 is talking about, yeah.
Yes.
Sir, what if somebody consents? Sir, what if somebody consents to? What if the person consents to take the stupefying substance? What if the victim consents to?
Let me tell you. You will have seen cases. There was a case of a herbalist who prepared, you know, bullet-resistant juju for a politician. Yoruba, they call it Okigbe. Ayeta. Yes, Ayeta. Okigbe is for cutlass. Ayeta is for bullet. It shoot you in any rally or whatever. It should not penetrate your body. So the deceased said, "Sir, I trust you and I believe you, but I want to test this drug here before I leave. I want to test the drug. I want to test this juju before I leave." I now gave a gun to the herbalist and asked the herbalist to shoot him so that I can be sure that the charm was effective. The herbalist shot him, the bullet penetrated him, and he died. You are talking of if somebody consents, but the court held the herbalist liable for murder. That is not a defense that he consented, that you should. So the same thing with poison. If somebody consents that you should administer poison, you see, that is a case of assisted suicide. You know, the case of assisted suicide. So you can see, it's not a defense that somebody consented. So I think we can go on.
Hello, sir.
Section 316, subsection 6 says that death resulting from willfully stopping the breath of any person for such purposes. That is, murder is committed where death is caused by willfully stopping the breath of any person for the purpose of facilitating the commission of an offense, for the purpose of facilitating the flight of an offender, committed offense. So, like I told you earlier on, that we are still going back to DPP versus Beard when we get to section 316, section 6. Because at section 316, section 3, when we are treating Beard as against Namiri, a rape case where the accused person held the throat of the deceased, and the court held that it was capable of endangering human life. So the case is also coming up here under 316, section 6. At DPP and BR, the accused had the throat of the victim to facilitate the commission of the offense of rape on her. And it was held that it satisfied the requirement of murder under section 316, so 6. So it satisfied the requirement of murder under 316, so 3 by holding the throat. You are willfully stopping the breath of that person. And that is the requirement of section 316, subsection 6. Okay? The offense of murder is punishable with death penalty. See section 319, subsection 1 of the Criminal Code. The offense of murder is punishable with death penalty. So we move on to attempted murder. We are through with murder. We are moving on to attempted murder now. And you can see that in section 320 of the Criminal Code. Section 320 of Criminal Code provides that any person who attempts unlawfully to kill, or with intent unlawfully of killing another, does any act or omits to do any act which it is his duty to do, such act or omission being of a nature to endanger human life. You see now, such person is liable to life imprisonment. So the general principles of attempt are applicable to attempted murder. General principles of attempt are applicable to attempted murder. I'm sure you have been taught attempt and conspiracy. Yes or no?
Yes, sir.
Aha. So you know what attempt is when a person begins, to do a particular act and set machinery in motion, but before the completion of the act, this and this and that, this and that. That is attempt. So if you know the principles of attempt, then it's also applicable to attempted murder. But there is a very fine distinction here. The actus reus for attempted murder is doing any act of such nature as to be likely to endanger human life. And this includes firing a loaded gun, as in the case of State versus Eric Ofole. The case of Eric Ofole, State and Eric Ofole, Ofole is OFOLE. And that's 1972, 2 ECS LR, 2 ECS LR, East Central State Law Report. Firing a loaded gun. You know when you fire a loaded gun, but luckily for you, the victim does not die. But you occasion what we call grievous bodily harm to that person as a result of the bullets. You are guilty of attempted murder. Importantly, unlike a murder charge, in which proof of intention to cause grievous harm will suffice for liability, such is not sufficient to grant a conviction for attempted murder. Rather, the prosecution must prove that the accused person actually intended to kill. You see now? So you can see the difference now. If you want to establish murder, you either establish that the accused person intends to kill or intends to cause grievous bodily harm. But when you want to establish intention, attempted murder, you don't establish intention to cause grievous bodily harm. You only establish intention to kill. So intention to kill, to cause grievous bodily harm will not grant attempted murder, but intention to kill. So in Cyril Ozuloke, Ozuloke is spelled Ozuloke versus the state, 1965, NMLR 125. The Supreme Court, in allowing the appeal, held that the prosecution failed to prove intention to kill. So it was a case of attempted murder. Supreme Court that the prosecution failed to establish intention to kill, but succeeded in intention to do grievous bodily harm. And the court said that it did not amount to attempted murder, but wounding with intent. Can you see now? Wounding with intent. Also, in the words of Lord Goddard, LCJ, in Harris versus Judge Wibro. Wibro is spelled W-H-Y-B-R-O, W-H-Y-B-R-O-W. 1951, 35 Criminal Appeal Report, 1 at 146. According to Lord Goddard is G-O-D-D-A-R-D. He said, and I quote, "It may be said that the law, which is not always logical, is somewhat illogical in saying that if one attacks a person intending to do grievous bodily harm, and that results, that is murder. If one attacks a person intending to do grievous harm, and death results, that is. But if he attacks a person and only intends to do grievous bodily harm, and death does not result, it is not attempted murder." Can you see? Can you see what Lord Goddard is saying there? If it doesn't amount to death, even though you attempted to cause grievous bodily harm, it doesn't amount to attempted murder. But if you intend to cause grievous bodily harm and death result, it amounts to murder. You know, if death does not result and you intend to cause grievous bodily harm, it only amounts to wounding with intent to, to do grievous bodily harm. Note that attempted murder is punishable with life imprisonment. Attempted murder is punishable with life imprisonment. So we quickly move to manslaughter, maybe for a few minutes because our time is almost gone. Manslaughter, Section 317 Criminal Code. Section 317 Criminal Code defines manslaughter as any unlawful killing which does not amount to murder. Any unlawful killing which does not amount to murder. You have to note that we have two types of manslaughter: voluntary manslaughter and involuntary manslaughter. A voluntary manslaughter is when there is intention to kill. When there is intention to kill, but your culpability is vitiated by the fact that you have a defense of provocation. You have a defense of provocation, or you have a diminished responsibility. A voluntary manslaughter is where there is intention to kill and death results, but your culpability for murder is vitiated by the fact that you have a defense of provocation or diminished responsibility. However, involuntary manslaughter is a situation where there is blameworthiness on your part, but no intention to kill. There is blameworthiness on your part, but there's no intention to kill or cause grievous bodily harm. Or where there is recklessness or negligence on your part, especially automobile accidents. Automobile accident, otherwise called automobile manslaughter. Maybe you are reckless, you are driving, your brake failed, you didn't take precaution, and you hit somebody, the person dies. It's a species of involuntary manslaughter. Where you are prosecuting an unlawful purpose and death results is also involuntary manslaughter. Then when you use excessive force is also involuntary manslaughter. Maybe armed personnel, or when you talk of police on duty, you see a vehicle, you stop and search, it's not stopping. You targeted to demobilize the vehicle by targeting the tire, but your bullet hit the head of the passenger, and the passenger dies. So it will come under involuntary manslaughter rather than murder. You know, so those are the examples. So Section 317 Criminal Code, then sections 188 and 189 of Criminal Law of Lagos State, 2011, Section 222 of the Penal Code, Section 222 of Penal Code. Then see the case of R versus Prentice for manslaughter. See R versus Prentice, 1994, QB 302. QB 302. QB 302. So this is a convenient junction to stop today. Next week we continue from where we stopped on manslaughter. I hope we can break for now. Or you don't have next class? Hello?
Sorry, sir. Sorry,
We
sir.
do,
The
sir.
related, sorry, sir. The latest section for the
We do,
Lagos.
sir. We have the
Lagos, for
we
criminal
do
law of Lagos,
another class.
Yes, sir. Yes, sir.
for criminal law,
189.
section 188 and 189. 188 and 189.
Okay, thank you, sir.
Then section 222 Penal Code.
Okay.
The R versus Prentice, the citation is 1994 QB 302. So we take it from there next class. Enjoy the rest of your day.
Yeah, thank you,
All
sir.
right. All right.
Thank
Okay. Yeah. All right.
So can I go on my question?
Okay, what's your question?
Yes, sir. So I would like to know the purpose of dividing manslaughter into segments. Like, why do we have voluntary and non-voluntary? Is there reduction of punishment for these types of manslaughter, or why do we have the differences?
I've told you that voluntary manslaughter is a situation where you have intention to kill and you kill. Whereas involuntary manslaughter is a situation where you don't have intention to kill. Something that is involuntary is not willed. You don't have intention, but death results. But when it is voluntary, you actually determine to kill and you kill. But your culpability is mitigated. Maybe you have a defense of provocation. For example, maybe you have defense of provocation. So it will be reduced from murder to manslaughter. Then if you are driving and you are reckless and somebody runs across your vehicle and you hit the person dies, you won't be charged with murder. It will be manslaughter because it's not willed, but you are reckless. So you won't go free. At the same time, it won't be murder because you didn't intend to kill. So it's involuntary manslaughter. Are you clear now?
Please, sir, what's the punishment for manslaughter, sir?
Life imprisonment.
Okay, thank you, sir.
But the courts can award lesser because in Interpretation Act says life imprisonment is the maximum for that offense, and that the court has discretion to award lesser. So they can award as low as 3 years, 6 years, 5 years, 7 years.
So, sir, does that mean that provocation is for voluntary manslaughter?
Huh?
As provocation, intent to kill done with provocation. Does that stand for voluntary manslaughter?
The defense of provocation is only applicable to voluntary manslaughter. It's not applicable to involuntary manslaughter.
Okay, sir.
Yeah.
Sorry, sir. In a case where there is an accident, like involuntary manslaughter, for instance, now, but it wasn't due to the fact that the driver was reckless, but actually on the path of the disease.
You have defense of accident in the criminal code. They must have defenses now. If you can establish that it is a defense of accident, you are absolved of culpability.
Criminal liability. Okay.
It's a complete defense. Defense of accident is a complete defense. acts that occur independent of your will. It's a complete defense. Unless it can be proved that you are careless and negligent, then that is when it now turns to involuntary manslaughter.
Sorry, sir. In the case of in that case where the tablets administered were not sufficient to constitute murder, can they charge the person for attempt?
They cannot charge for attempt because if a case for murder fails on the ground that courts held that there is no intention to kill, you cannot be guilty of attempted, because attempt to kill is also a requirement. Intention to kill is also a requirement for attempted murder. I don't know if you understand what I'm saying.
Yes, sir.
But you may be guilty of any other offense.
Thank you, sir.
Yeah, it's all right.
Hello,
Okay.
sir. Please, just one last question, sir, from me.
Last question, yes.
Yes, sir. You is concerning what Bolu just asked now, and with respect to section.
Is that
what
concerning
Bolu, the last speaker just asked about the case of that Madras 3 tablets.
Yes, that was Sadia.
Yeah. So now, section 316 sub 4 state that death that occurs in the process of facilitating the commission of an offense. Now, putting 3 tablets in the drink of somebody, isn't that like an offense? Although that could be kind of minimal, but it's still an offense. So if death results from that kind of scenario, shouldn't that be ascribed to be murder? Or what do you think, sir? Because it's somehow to me. I would like you to please put some more clarity to that.
Yes, you see, if a particular fact of a case fails under 3161 and 2, it doesn't mean that it may still not pass under 3163 or 3164. So it depends on the circumstances of the case. You understand now? So, for example, now, the case of Beard, it under 3163, it also passed under 3166. Okay? But the case of Osadiaye, was cited by Professor Bangboche to establish the fact that in construing intention, the quantity of stupefying or what you call overpowering substance used must be taken into consideration. That if the quantity is found to be insufficient to kill a person, especially in a poison case, that the court will not infer that the person has intention to kill. That is the principle enunciated in that case. You understand? And the court held that 3 tablets of Madras were grossly insufficient to kill a person by poison. So you take the facts as you have it. I don't know the full facts of the case. I don't know whether the person in the contest eventually died of another reason, or medical report, says that it is not the poison that killed him. But Bangboche just used it to buttress the fact that 3 tablets of Madras is grossly insufficient to kill a person, and that court will not construe intention to kill under that circumstance. Okay.
Bye, sir.
Okay, bye-bye.
Thank you, sir.
Okay. Thank
you, sir.
I'll go.